and welcome back to our weekly webinar series. We are discussing very important discussion papers today. Over to Anil, sir.
Thank you, Ankit. Welcome to 116th episode of AAA Weekly Webinar Series. As usual, we are very happy to be connected with you. And the subject today that we have taken up is the two discussion papers released by IBBI, one on 19th June 2024 regarding proposed amendments in CIRP regulations, and the other is regarding the liquidation regulations, which is providing a format for quarterly returns which are required to be filed by the liquidators. So we will discuss in detail. First we will start with the proposed amendments in the CIRP regulations. See, when we see again, as IBBI is very active based on the feedbacks, so with the various feedbacks that they have been receiving is the valuation process during CIRP. So the present process of appointing valuers and also the directions to the valuers how to conduct the valuation. Since the company's registered valuers and valuation rules 2017 has already been notified under Rule 8, Sub-Rule 2, the valuation rules have been provided, and it is already mentioned there that a registered valuer may obtain inputs for their valuation report or get a separate valuation for any asset class from other registered valuers. So therefore, the original valuer, he would always be responsible. And he would be responsible for the valuer that he has appointed for other class of assets. That is already there in Rule 8, Sub-Rule 2 of the Company's Registered Valuers and Valuation Rules 2017. Now, the present regulations 27 of CIRP regulations says that the two registered valuers will be appointed within 7 days of the appointment of the IRP, with the appointment of the RP, but not later than 47th day from the insolvency commencement date to determine fair value and liquidation value of the corporate debt. Regulation 35 of CIRP regulation says that the valuation can be conducted for different asset classes by different valuers. Regulation 35, sub-regulation 1, and the clause B says if the two estimates of a value in an asset class are significantly different, or on receipt of a proposal to appoint a third registered valuer from the committee of creditors, the resolution professional may appoint a third registered valuer for an asset class for submitting an estimate of value, and separately the significantly different is again defined there. Now, what is the feedback? What are the issues involved? One, that multiple valuations are required for different class of assets, and there may be some kind of inconsistencies or increase or decrease in the value, and the process also increases. The unified valuation approach may lead to some disputes and delays, and also it is inconsistent to the valuation rules under the Companies Act. So therefore, the IBBI thought that it all should be aligned, and the requirement of two registered valuers that may be even simplified for smaller companies including MSME. So the other important issue was to align with the valuation rules. So I think there is some background also, some kind of judgments like Cushman and Wakefield India Private Limited judgment versus Union of India, where Delhi High Court have actually commented on the valuation rules 2017, and the observations was that these rules are uh, valid, and these rules they have not seen any kind of inconsistency in the rules. So the rules have actually been a kind of also have the test of the Delhi High Court. Even the even the Ministry of Corporate Affairs also have given a notification on 23rd of October 2017, where it is said that for the purpose of Section 247 of the Companies Act, the IBBI is the regulatory authority, and the powers of the Government of India under Section 458 of the Companies Act was in fact delegated to IBBI. Now let us see the proposed amendment. Presently, in Regulation 2035 of the CIRB regulation, the wording used is that the value and the liquidation value computed in accordance with internationally accepted valuation standards. Now, internationally accepted valuation standards are now replaced with the terms of companies registered valuers and valuation rules 2017. So basically, in the Ankit, I think you would be able to explain it better because see, you do a lot of valuation every day. So,
Right.
what is the company's registered valuers and valuation rules, and how why this is internationally accepted valuation standards are replaced with companies registered valuer and valuation rules? What is this particular reason for changing this? And according to you, because see, you have a lot of experience of valuation. Yes, Ankit.
So two, three reasons. One, IBBI is in the process of drafting valuation, standards. So in time, there will be a possibility that India will have their own valuation standards, and those valuation standards will then be rather be the valuation standards that are required to be followed as per the company's registered value and valuation rules. So one, they would want that to be in synergy. It should not be that this rule, these regulations talk about internationally accepted valuation standards, and the the rules which are implicated or other required to be followed by registered valuers say a specific other standard. That's one part. Second part is that currently the rules talk about two options to choose from for the valuers. One, it says internationally accepted valuation standards or the valuation standard which is notified or which is prescribed by the RVO for its members. So currently, all RVOs apart from ICAI valuation standard, ICAI RVO have uh, has notified and said that its members have to follow the international valuation standards as notified by IVS. IVSC is the international body which comes out with international valuation standards. Now, this international valuation standard is different from internationally accepted valuation standards. Internationally accepted valuation standards can be more, other also. So there's a valuation standard in the US, there's a valuation standard in the UK, in Europe called Tegova. So there are various valuation standards across the globe, but most of the RVOs in India have accepted or rather adopted international valuation standards. So this is what I think this is a one streamlining, that rather than double reference in both the rules, they have simply said that the standards should be those standards that are, those requirements that are already stated in the regulations. And in future, maybe the regulations can also come out with a change depending on when we have our own standards or when the RVO keep changing their applicable standards.
Now, within this proposed amendment, one, that the internationally accepted valuation standard is replaced with the terms of companies registered valuers and valuation rules 2017. And I also see that the companies registered valuer and valuation rules also have an option of internationally accepted valuation standards.
Yeah,
The
it rather
option is already
says.
there.
So Rule 8.1 of registered valuers and valuation rule says that the registered valuer shall conduct the value considering sorry, conduct the valuation complying with Rule 18 of the standards of these rules. Rule 18 says that Indian standards will be notified whenever they are notified. Then it also has a proviso that till the time these rules are not notified, then internationally accepted valuation standards or valuation standard adopted by the RVO can be used by the registered valuers.
No, within this regulation itself, now the IBBI is also proposing as a proviso, provided that the resolution professionals shall facilitate a meeting wherein the registered valuers shall explain the methodology being adopted to arrive at valuation to the members of the committee before completion of the estimates. And further, the subsequent paragraphs in the proposed amendment regulation where two registered valuers have been appointed and the estimate of values are significantly different, or on receipt of a proposal to appoint a third valuer from the committee of creditors, the resolution professional may appoint a third registered valuer and for submitting estimates of the value of the assets. Again, the average of the two highest would be considered as the value and the difference would be 25%. So this is where the amendments are. One, in this amendment, we have seen the company's rules, valuation rules will be adopted, and valuation rule has both options, internationally accepted valuation standards as well as valuation rules. Secondly, the other part is that the discussion with the valuers and the committee of creditors, and that is regarding the methodology adopted to arrive at the valuation estimates is part of this regulation. And then how to arrive at the liquidation value or the fair value when there are more than one registered valuer is appointed in any case. Now, this is one part of the amendment, and the other amendment which is proposed through this discussion paper is one valuation estimate for companies up to a certain asset size and for MSME. So there are two things. One, that the some court observations are also there, like in the case of Swiss Ribbon Private Limited, the court observed that there should be some relaxation in the process for MSME, and also for that reason, even Section 240A was also inserted. However, the Regulation 27, Regulation 35 is the same for smaller sized companies, asset size smaller, or even for the MSME. But therefore, the feedback which was going to IBBI was higher cost, delay in getting the report, inconsistency in the two reports, and then finally the delay in the resolution process. So therefore, now the proposal is from IBBI to amend the regulations that the corporate debtor having size of the assets as per the latest audited balance sheets, which is up to 1,000 crore, or the company, in case it is classified as MSME, then there is a requirement of appointing only one valuer. So when we are saying only one valuer, then it is also very clear. However, the COC has been given a power. If the COC wants that more than one valuer is to be appointed, then COC can appoint two valuers if necessary. And in case the two valuers are giving significantly different valuations, then again the third valuer can be appointed. However, this particular decision has been left to the committee of creditors, because the committee of creditors would know in each case what is the importance of valuation and how intricate the valuation is. So therefore, looking into the complexity involved, the committee of creditors can take a decision whether they would like to go for two valuers or they would like to go for one valuation. So this is also, since there may be in future, there may be a possibility that the government is thinking of kind of introducing the insolvency law for partnership firms, for individuals other than personal guarantors. So therefore, this kind of relaxation for MSME is also a kind of welcome. So the even Swiss Ribbon has also said, in the case of even Insolvency Law Committee, also said that this is something which some kind of relaxation is required for smaller companies. Now, let us understand what is the proposed amendment in Regulation 27, which is the starting section where the RP is under obligation to appoint valuers. Now, the present regulation says that the RP is supposed to appoint two registered valuers, and now the regulation says that the proposed regulation is the resolution professional shall, within 7 days from his appointment, but not later than 47th day from the insolvency commencement date, appoint registered valuers to determine the fair value and the liquidation value of the corporate debtor in accordance with the Regulation 35 as under. Now, in the regulation, the clause A, see, the further in Regulation 27, it is said that one registered valuer in case the corporate debtor is MSME or its asset size up to rupees 1,000 crore as per the latest available balance sheet, provided that the committee may decide with reasons to be recorded to appoint two registered valuer. In case asset size is small, in case the company is MSME, still the committee of creditor has the power to appoint two registered valuers. But the committee of creditors will have to record reasons why they want two registered valuers. That it is a thoughtful decision. It is not a decision which is just by impulsive. Then, in case the assets are more than 1,000 crore as per the latest book value, and the company is not MSME, then the requirement is to appoint two registered valuers. Then the requirement is two registered valuers. Now, in this case, Ankit, when we say the word class of asset has been removed now, it is proposed that for each class, it is now removed. Earlier, it was very clear that in case we read Regulation 35, it is very clear that for each asset class, the valuer has to be appointed. To estimate of a value in an asset class. Now that asset class word has been removed, so that means that one valuer can be appointed, and that valuer can also take input from the other experts. So this is which is the significant part of the amendment, that instead of 6 valuers, instead of valuer for each class of assets like land and building, plant and machinery, securities and financial assets, now there is a requirement of appointing one valuer, and the power has been given to that valuer to take input and also take separate reports if required from other valuers. So Ankit, I think you need to provide some more input on this. What is this significant? And one valuer, and he has the power to take input from the other valuers or from experts. I think you need to explain this in detail.
So basically, Rule 8.2 of companies registered value and valuation rules envisages the idea, rather even 7C also talks about that. So 7C talks about conditions of registration, and 7 talks about conditions of registration. 7C says that the registered valuer shall not conduct valuation of the assets or classes of assets other than for which he or she has been registered by the authority. Then 8.2 talks about, it simply says that the registered valuer may obtain inputs for his valuation report or get a separate valuation for an asset class conducted from another registered valuer, in which case he shall fully disclose the details of the inputs and the particulars, etc., of the other registered valuer in his report. And then it also says that irrespective of the nature of inputs or valuation by the other registered valuer, the original registered valuer should continue to be responsible and liable towards the valuation report. So this is all centered around the idea that there is a possibility that, uh, let's say, I'm giving you an example, that a securities or financial assets valuer is given the task of valuing the company as a going concern, and he finds that there are certain non-operating assets in the company, which might be a land and building, might be a plant and machinery, and he now wants to get a valuation done for those assets so that he can add that value in the total value and then give a value to the client. So in that case, he has to go to another registered value, take his report and make that report a part of his own report, and then he can say that yes, this is what I have trusted on. I have ensured that this report is also as per the standards, as per the regulations, and I have taken this value. So the ownership does not change. He continues to be responsible for that report as well, but he can trust on an independent valuer's report to come out with a value for the assignment that was given to him. Now, if we envisage from the IBC perspective now that one person says that I am I am bidding for, I am quoting for the valuation assignment of all three asset classes, and that person says that I am, let's say, the land and building valuer, and the PNM valuer and SFA valuer will be this person and this person who will I will be asking for giving me the report. So with the new regulations, the report or the mandate can be given to that one person, and that the other two people then can give support services in respect of giving that report to that person. So this is what is envisaged now, that this can happen now. Earlier, we have seen practically what has happened is that there are certain individual valuers who work together. They would, give a quote together, and they will give three different quotes for three different asset classes. Their appointment will happen in differently by three appointment letters, but in a way they are working together. So this is a way out for them to escape the requirement of an RVE and still work as a team. So now I believe that if the entity is getting appointed, the entity will again can always be appointed the way it was appointed earlier for all three asset classes. Entities partners can then work there. If the entity does not have, let's say, a specific partner for a specific asset class, the entity can choose to outsource that work to another registered valuer and make that report part of their own report. That's also possible. So these are the changes that have happened.
So now, Ankit, let us understand the for the liquidators or for the resolution professionals, it is not mandatory to issue 6 engagement letters, two valuers land and building, two valuers plant and machinery, and two valuers for securities and financial assets. The liquidators and the resolution professionals are only supposed to issue 2 engagement letters. In that engagement letter, they can also say that for other class of assets, you are authorized to take input or you are authorized to appoint other valuers. So
In
there is a
case they are,
possibility
in case the appointment letter is being issued to a person who is not an entity.
who is not an in. So in case
The entity also for all three asset classes. There are entities which are only for two asset classes, one asset classes. So if the
so
entity is for all three asset classes, the award can be given without this clause also.
So in case the this clause can be given in the case of entity as well as in the case of individuals, because see the basically the risk of the entire risk lies with the primary valuer. So there can be secondary valuers. The risk of secondary valuers are not they are not responsible towards the regulator. They are responsible towards the primary valuer.
They are responsible to the regulator also. But it becomes a dual responsibility. The person who is getting the work done from that valuer, he also shares the responsibility.
So, see, what do you think? It is this is something which is required, or
No,
it will
this is a
create.
way out. This is a way out that has been thought of because the feedback that went to IBBI was, and I have given this feedback myself multiple times, that let's say there is a going concern entity, and that going concern entity has to be valued maybe using multiple methods for the entity as a whole. Now, dividing those that entity's assets, going concern entity's assets within different asset classes has always been a challenge. So we traditionally have always given one report for all three asset classes wherever the company is a going concern, and wherever it is, the valuation methodology that can be applied is to value the assets independently and or the piecemeal basis, then we have given the value separately. But with the new regulations that came in earlier, where the requirement to compare the value was on an asset class level, change that created a problem, that many a times the classification with respect to a particular asset class was a problem. Many a times there were certain assets which were belonging to the company which were a question as to where do you park them. Now, in one of the cases, I remember that there was certain litigation that was happening with respect to a land. Now, we said that this right against this land is something that can be considered as a land and building asset also, and as an SFA asset also, because it's not a land and building right, but it is a right in a land and building. So there can be complex assets in a company like that. Similarly, in case of a going concern, there can be intangible assets which are not part of books of accounts. There can be goodwill that is not part of the books of accounts. Now, in case somebody says that okay, you value the asset separately and value the going concern entity separately, there might be some values which are not making any sense at all.
So in few of our cases, we also found the paintings. We also found jewelry, which is and neither the part of which is nowhere in the three classes.
Clarity, so you kind of say that okay, these are maybe SFA assets because they are clearly not land and building or P&M assets. You put them in the remaining
But
category, something like
there
that.
are specialized people. They value the artifacts. They value the
So
jewelry.
rule 82 allows you to appoint those experts. Rule 82 is very clear that you can appoint experts or valuers who are required with respect to certain asset classes.
So this is now I think this is the time that on these two value, the two amendments, we can take questions, and we can also take some people who want to say ask a question.
So one question that has come from Ravi ji is that in some cases the RPs are appointing the valuers, but even after 5 months they're not able to provide provisional balance sheet as on CRP commencement date because of non-cooperation from the promoters. As valuer, they're sending regular reminders, but they're not getting this information. So my answer to Ravi ji is that Ravi ji, you can always talk to the RP in this case and understand that you can give a report which is based on an earlier balance sheet, because the provisional balance sheet or balance sheet has only one role to play, which is that whatever is the that one role to play, that is that whatever are the assets in the financial statements are covered or taken care of by the valuer. So in case the latest balance sheet is not available, you can use the earlier balance sheet. I don't think this is a deal breaker for the RP or the valuer. You can actually proceed with valuing those assets which are physically available out of the assets which were reflecting in the recent balance sheet of the company. Then Amir ji is saying that is it mandatory for RP to entrust the SFA valuer to carry out CD's valuation under IBC? What about valuation during liquidation? SFA valuer is not mandatory in any case. One can always appoint other valuers. SFA valuer is required to be appointed only where we feel that there are SFA assets in the company which are requiring a valuation. There is
But
no
now, as
compulsion.
per the proposed uh, valuation regulations, even the resolution professional can appoint a SFA valuer, and then it becomes the duty of the SFA valuer to engage somebody who can value land and building, and also to engage somebody who can value plant and machinery and other assets, if any, like the artifacts, like the jewelry or any other where
I'm
motor
of the
vehicles.
opinion that can be the other way around also. There is no mandate that it has to be an SFA valuer. It can be a
No,
land and building valuer who is
yes,
getting everything else done from other valuers.
any one valuer. So
So
any one.
there is no requirement per se in these changes that have come out that only an SFA valuer is required to be appointed.
No, I think anyone who has a better connect in the market, who has a better credibility in the market, he will fetch the assignment and he will be able to give the work to land and building valuer and to plant and machinery valuer and to the jewelry valuation and to the like artifacts valuation. That kind of the one valuer that will be engaging, he will be taking the decisions about the other values. So this is what is the present regulation. And any other question? Ankit?
Then we have Mr. Iswaran. He says that there is a method open for valuers for for enterprise value of the asset which is defective. I didn't understand the question. Amir ji is asking, do all the three asset class values present before COC to explain the valuation mechanism or as per the revised regulations of IBC? So it is up to the valuer. Like we always, when we present the valuation reports, we take our team along with us, not only the registered valuer partners. And so the objective is that if there is any question at all which needs to be answered, it can be taken care of by our team. So we never say that others are required or not. So I think if somebody has done the work and he can be part of a meeting and he can clarify if there are any questions. That's always better. Then Gitika ji is saying, as discussed, a valuer as per the proposed amendment can take inputs. Is the term input inclusive of report? If yes, my question is how one valuer can authenticate work of the other valuer. It's not authentication, it is taking responsibility that the valuation report is as per the regulations, as per the rules. All the components or contents which are required to be part of a report are already there in that report. So that I believe one valuer can always understand that whether these 8, 10, 20 requirements are taken care of by the valuer he is working with or not. So he continues to be. This is like a. It's like if you delegate some work, you continue to be responsible. It's like that theory.
Now, even otherwise, the wording mentioned there is the take input or take a report from other valuer.
So that's
So
also there.
even input and a report, both are the options available. And in case the input is taken, I believe it is the duty of the appointed valuer to create evidences about the source of this information in case he has got it from some other expert. That's what we feel.
Then I'm asking Yogesh Gupta ji to speak. He has raised his hand.
On same continuation of the last question, I mean, can the valuer do the job of plant and machinery, SFA valuer do the job of a plant and machinery valuation or land and building valuation on its own, or he is compulsorily required to take the expert's opinion on the valuation of plant and machinery and land and building?
Rule 7C bars the valuer from taking up the valuation of an asset class for which he is not registered. So therefore, the possibility of him doing the valuation on his own is not available at all.
So, what is the logic behind this change? If one
Logic
valuer
is
is appointed
logic
and
is that
the other
logic
valuer's appointment is
logic is
required,
logic is that the IBBI, I believe in IBC process, was discomforted by three valuation reports coming in, and then the three valuation reports being matched with the other report. So therefore, they changed the mechanism that one report will come and one report will take care of all the asset classes, and that report or that value can be compared with the other report. That is the idea.
So issuing six engagement letters as against now one or two, depending upon the size of the corporate debtor.
okay, thank you.
Then we
Ankit, your
have
voice is coming very low.
I will try and correct that. Then we have Mr. P.K. Mishra and Mr. Antila, if they can
Yeah,
speak.
yeah. Good morning. My question is very simple. What about the disclosure requirement in terms of when we appoint one valuer for all the class of assets, and he appoints like two more valuer in different class of assets? Then how we control the disclosure requirement?
Very interesting question. So disclosure requirements also need to be perhaps have that amendment because you are sharing information with the third party which is not perhaps interacting with the RP directly. So whenever you're sharing the disclosure requirements, whenever you're appointing maybe a third or fourth valuer to work with the registered valuer, maybe an updated disclosure has to go to the RP's office.
So the
There is no.
disclosure regarding two things, Ankit. One is the disclosure about any relationship with the corporate debtor.
Hmm.
That, of course, is a separate disclosure. And the second is the disclosure about appointing another valuer for some part of the valuation assignment, and also disclosure for taking inputs from other valuers.
Yeah.
So I believe in the morning, me and you were reading some of the rules of the valuation rules, and it was very clear that a particular asset would not be valued by a valuer in case he is not registered for that. I think that particular regular a rule, we have to show it on the screen to everyone, that as per this rule, a SFA valuer will not be able to give any comment on the valuation of plant and machinery and land and building. That rule is significant that we discussed before the webinar, Ankit, in the morning, early morning today.
Yeah, I can share it on the screen right now. So 7C is what this is. So it says that the conditions of registration, the registration granted under Rule 6 shall be subject to the condition that the valuer shall, in his capacity as registered valuer, not conduct valuation of the asset or assets or classes of assets other than for which it has been registered by the authority. So this is what we're talking about.
So this is very clear that if a person is registered for land and building, he will not conduct valuation of other assets other than land and building.
Yeah.
Even if he is given the assignment, but then he will outsource it to somebody else. And that outsourcing also should be disclosed to the RP, and the RP can disclose this further to the
IBBI.
Committee of Creditors.
So that means if the registered valuer which appointed by the RP or liquidator, and that valuer appoints somebody else to more valuer, then he has to get the disclosure in the same way as RP get from the appointed valuer. Because how he will know what is the relation between the third valuer or fourth valuer with the CD and all.
I think this is an indirect appointment of a professional, which is the professional appointed by a professional. I believe presently the IBBI has not made any regulation for then it is the duty of the primary professional to take similarly confidentiality undertaking from the other valuers who are getting appointed. In case of employees, the undertaking is always there in the appointment letter, but in the case of engaging another professional, I think it is the duty of the appointed valuer to take this kind of confidentiality undertaking from the other professionals who are being shared the information.
Okay, thank you.
We have a question from Amir ji.
Sir, good morning, sir. Sir, this is regarding 8.2, rule number 8.2 we are discussing here. I'm talking about rule number 8.1, wherein it is mentioned that the valuer shall make valuation report as per internationally accepted valuation standards, B, valuation standards adopted by any registered valuers organization. As a valuer, whether the valuer can use both the valuation standards?
No, so
because here there is no or.
It says or. It says or. So
It has or. It has
in
or.
case you read
There
the
is no
updated,
or mentioned in here, sir.
it
Is
was
mentioned on
amended.
the third C only.
It was amended in 22 on 22nd November 22. Perhaps you are reading the earlier version.
Earlier
The
version
revised,
only. Yeah.
no, the
then
revised
okay, sir.
version.
Okay.
So I'm just showing this.
Because in one of my reports,
this is the revised version. It says or. See.
Right, sir. Okay. Thank you very much.
It was already amended in 2022.
So I think Mr. Pankaj Tibrewala is also, Pankaj Tibrewala is our Kolkata-based partner. He is also interested in speaking, or he is also interested in asking a question. Yes, Pankaj.
So basically my question, my view on this disclosure only, sir. This was, I think the way you have clarified, I am also thinking that way, that the valuer, the appointed valuer by the IRP or RP as the case may be, has to do this compliance at their end by taking this disclosure from the respective third valuer with whom they are appointing, and then can disclose themselves, or can be done through the IRP or RP.
Yes, Sangeet, I believe.
Yes, I think so.
Very clear.
Then Abhayji, maybe you can say what you want to say. So.
Yeah. Good afternoon.
Yes.
In fact, the present proposal of amendment, I don't think that is required. I don't know why IBBI is doing it. As per the clause previously explained, where a valuer can take an input from other valuer, or say give the assignment to the other valuer when there are number of assets within the assignment, asset classes within the assignment. So in fact, if I remember correctly, when we started this in 2018 or early 19, I used to do similar kind of assignment where I used to take the assignment and then it was being distributed among two more asset classes, and their inputs were taken, and then one combined valuation report we used to submit it. That was the modus operandi. I don't know in between verbally what IBBI changed it and told the RPs to appoint 3 individual valuers. There was that is nowhere mentioned in the regulation that 3 independent valuers have to be appointed asset class wise.
No, it is mentioned in the regulations. It is mentioned that in case the two valuation estimates received from two different valuers, and that too for different classes, if those are significantly different from each other, then the committee of creditors will, RP will decide to appoint a third valuer. Even the
I am not referring to that, sir. I am
Even-
not referring to that. What I am referring, 3 asset classes. Like any means your insolvency assignment will have 3 asset classes involved there: land and building, plant and machinery, and financial asset.
So it is
for
a combination of, we understand your question. It's a combination of valuation rules and also the regulations. In the regulations, when they defined significantly different, they also refer to class of creditor, class of assets. However, in the case of valuation rules, Ankit, you can also point out the relevant rules where it is said that the valuer, registered valuer, can only do valuation of those assets for which he is registered. So for other assets, it is either we have to appoint, because see this outsourcing the work or taking the input from experts, that was not there in the regulation. So it was very clear that for each class of asset, the valuer has to be appointed, because this this regulation was not there, which is being inserted now. So therefore, it was required to appoint and get evaluation separately for land and building, plant and machinery, and securities and financial assets. It was required that, because why it was required? Because the valuers were. Ankit, you take up.
No, no. So you mean to say because this is existing in registered valuer rule since beginning about the asset classes, taking the expert opinion and all. That clause is since beginning itself. So you mean to say that this had to be brought in CIRP regulation?
No, I think what we have clarified here is that the regulations required the value to be compared on asset class basis. Also, it says that the valuer should be appointed for the for the whole valuation purpose. So when we read both these clauses together, the normal sense came out that we have to appoint either an entity which is qualified to take up valuation for multiple asset classes, or we have to appoint 3 different valuers for 3 different asset classes. There is no clarity on the fact that I can appoint a land and building valuer, and then he will be indeed appointing other 2 asset classes value. So now with these changes in the regulations, it has emerged now that rather it is a direction towards the idea that we have to get the valuation done from one person. He will appoint 2 more valuers in case he wants to do that, in case the asset classes are there. All right.
Okay.
Ankit, I think Mr. Ishwaran, who is our partner
I've
from.
also asked him to speak. Maybe Iswaranji can unmute himself and say and speak.
Good morning,
Mr.
sir. Good morning, sir. Good
Morning,
morning.
morning.
See, my question is, there are certain assets are the basic thing to create income. So land and for the land and building. If the land is classified in the wetland as a wetland, then for valuation purpose, we cannot give you the dry land valuation. Similarly, if the assets, building and other things also is located in the wetland, There also in a wetland, the promoter is not supposed to license to construct building. But in one particular case, which I am also involved, the land is in the land classification is wetland, and the building is constructed is without license. But that unit is making income of average 1.5 crore per per month. So that means even the asset is defective, but income is there. So in that case, there is a method called, to my information, enterprise value based on the last 5 years profit, turnover, and all those things. That is my question. In this also is done by the land and building valuers. Not we are not giving to investment valuers. Am I correct in this case?
No, I believe I believe you are correct by saying that, but then somehow because of the fire drill at this hotel where I am staying today at Mumbai, there is a mock fire drill, so there was a lot of noise. So therefore, I could not hear. Ankit, in case you could hear, you can answer this.
So, so what I think what I can ask is Mr. Easwaran to just repeat that question part of it. If you can just repeat, please.
I will. The particular CD is having income from land and building. This is asset.
Hmm.
This land and building is situated in a defective way. That means the land, entire land is dry land, wetland. And in Kerala, in wetland, it's agricultural land. They are not supposed to construct anything there. But this particular CD, years back, without obtaining licenses, has constructed all the land, building and rooms and all. And once the evaluator is appointed, the valuation has also done, but the evaluators are not able to give the uh, price for a dry land because the land is classified as wetland. So that means if the particular land is meant to getting at least 5 lakhs per cent, they were not able to put that value. They were able to put only 1 lakh.
So
Similarly,
understood. Understood the question.
the unit is producing not less than 1.5 to 2 crore per month also. So, valuation point of view, if there is a check the value of the land, the value will be very low. So I told them, why don't you consider enterprise value? Because for last 5 years
I think
balance sheet,
we understood now. One, that it is a question of unauthorized construction on
yes.
on a land. Now, but then this unauthorized construction, by virtue of some time, it is still having some value. The registered valuer, I think, will make an estimate based on the income that particular unauthorized construction is earning, and based on the capitalization method of the earning, and then the registered valuer will also see that in case of the law is enforced, then that building can be even erased. It can be removed from that land. Then what would be the value? I think the best estimate would be take a mean of these two values. One is the present value based on the income, and the other is the income in case this law is enforced. And then what would be the value? So mean of these two can be the best value for such assets. Ankit is a registered value. He can even suggest anything better than what I said.
So this is a clear case of land and building valuation only. There is no other asset involved here. But land and building valuation can also be done using income method. And wherever the properties are leased out, or the property is having some rental income, it is possible to estimate the future cash flows and value the land and building accordingly. And of course, there is always this idea of providing for any unsanctioned, unregulated construction. There are two ways to go about it. One, if there is any compounding or any way, any expense which can be incurred to regularize this, or any conversion charge for converting this wet to dry land, that is taken care of. Otherwise, the other alternative is to put in a risk premium, and then using that risk premium, you discount the cash flows with a higher number, decreasing the value to that extent. So this is the normally the practice in this kind of evaluation.
Ankit, my point is under the new state's law, will there is any change because the third, if we need to appoint
Under the new regulation, also you will be required to appoint a land and building valuer. Even earlier, for this kind of an asset in the company, you would have required to appoint a land and building valuer, because there are no other operations in the company. Now, I will give you another example. Let's say that this building is not rented out, and this building is being used by the company to generate cash flows, doing some business. Now, in that case, there will now be a requirement to value the company as a going concern and also value maybe the land and building separately in case you would want to have that happen. So therefore, then you will have two asset classes coming in. But since this building is earning rental income, it is a clear case of land and building valuation only, unless and until you have some other assets in the company which are SFA or PNM assets.
So Ankit, we need to cover up a little more, and I think we have to move to the next part of the amendment, which is the appointment of authorized representative in the case of class of creditors. So presently the IBBI has seen that the difficulties are being felt by the while the AR is appointed, and the AR is appointed, like IRP has to identify. Let us understand the present process. IRP has to identify 3 proposed ARs, and IRP has to take their consent within the first 3 days so that their name is published along with the Form A inviting the claims. Then, see, even this is also a very Herculean job to find out 3 people, and that too from the same city or same state, from the same state where most of the class of creditors are residing or having their operations or business. Then the voting, everyone who would be submitting their claims will have to choose one out of the 3 ARs. Then comes is the highest number of the consents received. Then the IRP will see who has got the highest number. Then accordingly, the IRP will file an application before the adjudicating authority for approval of the AR, so that the AR gets appropriate powers from the order of the NCLT, and then the first meeting will take place. Now, the issues are that the RP is doing everything correctly. The claims are being verified. The maximum number of preferences have been seen, and the RP has filed the application for approval of the appointment of AR before adjudicating authority. But somehow, for some reasons, that order for appointment of the AR is not received before the first meeting, because the first meeting has to be done within 30 days. So thereafter, now what is the position of the AR? AR has actually been, it is only the maximum consents given by the by the class of creditors, and then the application has been submitted. Order has not come. The AR cannot function. AR cannot come in the meeting. AR, because this is what is thought. Now, when we do this, it actually will cause some kind of inconvenience, and the rights of the class of creditors will actually get kind of disturbed. So therefore, the IBBI thought that there should be some amendments in the regulations. Now, there are 2 things that has been allowed by the IBBI. One, that even if the adjudicating authority has not given the approval, the AR can be can attend the meetings of the committee of creditors, and AR can come and appoint as interim. AR can also work as interim AR till the time the order is received. Also, it is recommended that when an application is submitted to adjudicating authority for approval of the AR, there should be one of the ground that this person, the proposed AR, are being admitted as interim authorized representative and is taking powers, taking participation in the process, and that should also be ratified. So this kind of prayer is also recommended, and because this is also based on various judgments where these kind of disputes were raised, and now the amendment, Rule 16A, is amended, and there is a proviso which is being added. And the proviso says, provided that the insolvency professional selected under sub-regulation 1 to act as the AR for a class of creditor shall be entitled to attend the meeting of the committee of creditors and perform such duties as provided under Section 25A from the date of submission of the application for his appointment as authorized representative to the adjudicating authority till such date of his confirmation by the adjudicating authority. Now, this is the scenario, and I believe in the proposed regulation it is not said, but in the preamble it is also said that while submitting the application to the adjudicating authority, it should also be said that the AR is participating in the minutes in case the order is delayed, so that the adjudicating authority can also ratify all the actions taken by the AR before the date of the appointment, however, after the date of submission of the application to adjudicating authority. So any comment on this from your side, Ankit?
I think this is fair. I don't see anything else that I can add to it.
So in fact, anyway, I would not comment. But then I say this this is a welcome. This was a need which, in fact, we felt in various cases, and we felt that in case the AR is not representing in the class of creditors, how the meeting would be conducted, the rights of that class of creditors would be adversely impacted. So we, in fact, allowed in some of the cases, after taking permission from the committee of creditors, to admit AR in the meeting and also to conduct the voting through the AR. So that, in fact, we have done in some cases just to look after the interest of the class of creditors. So, Ankit, the next amendment is the release of guarantees in the resolution plan. So this is also based on various contradictory judgments. So one judgment, which is Lalit Kumar Jain versus Union of India, which is regarding the kind of constitutional validity of initiating insolvency process of personal guarantors. In this judgment, it was very clearly said that the guarantor's liability, when the resolution plan is approved and the resolution plan is also approved by the committee of creditors, that will not be considered as the waiver of the personal guarantors. So it is very clear that even after the resolution plan is approved, the financial creditor who has the corporate guarantee or personal guarantee, they can proceed against the guarantors. So the guarantors can be corporate guarantors or it can be personal guarantors, but the guarantors can be proceeded against by the creditors even after the resolution plan is approved. Now, in this case, this is very clear that this kind of judgments were also there. But in case we see, like the Lalit Kumar Jain, like it was very clear, and in some of the other judgments, like in NCLAT judgment in SVA Family Welfare Trust versus Ujjas Energy Limited. So in this case, the resolution plan was approved where the personal guarantor's responsibility was also kind of settled, and that was also kind of waived in the resolution plan. So there the question was raised that, like, what about the rights of Bank of Baroda, who has not voted in favor of the resolution plan, and Bank of Baroda is a like kind of abstaining or is a dissenting creditor. Now, the NCLT rejected the resolution plan, and NCLAT, on an appeal, NCLAT in fact approved the resolution plan. NCLAT also referred the judgment of Vijay Kumar Jain versus Standard Chartered Bank, where it was observed that approval of resolution plan binds personal guarantors and may scale down the debt of the principal debtor, thereby affecting the personal guarantor's liability. Lalit Kumar Jain was also referred. Commercial wisdom of the committee of creditors were also referred, but the decision was that yes, the personal guarantee can also be resolved through a resolution plan. That was the decision of NCLAT in this case, which is the Ujjas Energy Limited. But looking into this, the IBBI thought that it is better to clarify this because there are a lot of litigation which is like around this issue. Now, in the regulation 37, one resolution, like a reduction in the amount payable to the creditors, is 37F. Now, in this 37F, a proviso has been added, which is Regulation 37, Sub-Regulation F, a proviso. Provided that a resolution plan shall not prevent the creditors from enforcing their rights against the grantors of the corporate debt. That means the resolving personal guarantee or resolving corporate guarantee is not possible through the resolution plan now. So the corporate guarantee and personal guarantee, in case it has to be resolved, it has to be resolved separately. It cannot be clubbed together with a resolution plan. That is something which is primarily to prevent various kind of connivances, various kind of conflicting judgments. So this clarification is the most welcome clarification that should be like honored. So then coming to the another note on the format of the liquidation process report. Now, the format on the liquidation process report, in case we try to see that, that is something which is simply a format. It is not a discussion paper. It was released on 21st of June 2024. However, this format, again, it was like public comments was invited. Instead of discussion paper, IBBI has called it as a format. And this is also have reference to a circular of the IBBI dated 22nd of February 2024, which actually says that this progress report, quarterly progress report, should be also shared with the stakeholders consultation committee, provided they issue a confidentiality undertaking. So this was also a reason, this was also a way the stakeholder consultation committee or all the stakeholders are kind of appraised about the liquidation process. Now, this format is in fact very, very extensive. So this will increase a lot of work for the liquidators. So this has the details, like all the details of the liquidation process is actually covered in this quarterly report format. Details of the corporate debtor, like the name of the liquidator, whether it's a going concern or not, valuation processes, the valuation during the liquidation process, insolvency commencement date, professionals appointed with the date, then synopsis of whether what was the reasons of the company going into liquidation, present status of the process in English, then the list of the various events, actions, like from the liquidation commencement date to the previous progress report, everything has to be mentioned date-wise. Like for that all 1 quarter, date-wise progress has to be mentioned in this progress report, and the summary of receipt and payment is separate, and detailed receipt and payment account is separate. So summary of the receipts are also categorized. What was the original balance? What is the now received? What are the payments made? And then how the money has come in from the sale of assets, from assignments of assets, receivables recovery, and recovery from statutory authorities, going concern revenue. All this has to be mentioned separately, and then all payments have to be mentioned separately. One is that even the non-fund based exposure of the banks is also supposed to be mentioned in this format. How many performance guarantees are outstanding, how many financial guarantees are outstanding, how many letter of credits are outstanding, how many comfort letters are outstanding. All these are called non-fund based exposure, and what is the total outstanding, how are these being attended to. So then the distribution made to each and every creditor, that is also supposed to be mentioned. There are a lot of annexes that we are supposed to appoint. That means that wherever we appoint a professional, the one document has to be attached. That means engagement letter. Or in case cessation of professional, then also a kind of a document which is evidencing the cessation of that appointment of a professional. Then the any kind of security interest which is not relinquished in favor of liquidation estate, the liquidator is supposed to keep a track of it and supposed to keep report on it and supposed to seek the information from those persons who have the security interest of those assets, and also keep a track when it was sold and for how much it was sold, and whether there was any account which has to come back to liquidator. Any asset which has not been put up for sale and why it has not been put up for sale, all this is a detailed information and also constitution of the stakeholders consultation committee. In case there are many workmen, in case there are many employees, then the liquidator has to facilitate them to appoint one representative. In case there are many government authorities, then the liquidator has to actually facilitate them to appoint one representative. In case there are many shareholders, then the liquidator has to facilitate them to appoint one person who has three representing the stakeholders. Similarly, operational creditors, similarly, home buyers, similarly, debenture creditors. So the liquidator has to facilitate a process where they would appoint their representative to participate into the SCC. Then when how many meetings happened, what was the gap between the meetings, why the meeting delayed, why the meeting was not there as per the revised regulations. So considering this, like the job of the liquidator has increased to a great extent. The scope of work of each professional has to be mentioned. Engagement letter was issued or not, date of appointment, fees payable, everything, and is supposed to be reported every quarter. And this report will also go to stakeholders consultation committee members. Assets put up for sale, how many failed auctions, assets which are not being put up for sales, buffet transaction details, other litigation pending, what kind of recovery processes are being conducted, detailed receipt and payment account. So all this has become part of the quarterly exercise for each case. So this is what, Ankit, we have today. Already it is 1 hour or 7 minutes. I think I don't think we have now time for adding more questions, but still we can take only 2 questions about, and that should not be about valuation. That should be the other amendments to the CIRP and also the format for liquidation quarterly statements.
So I will try and find out a question. Question is that if IP has been replaced in first COC meeting and AR is not appointed, what will be the status of AR proposed by him?
No, that status will continue because that AR is not proposed by the IRP, that has been opted by the claimants. So the IRPs only have made an application to adjudicating authority, and that application will continue, and that application will be decided by the adjudicating authority, and that person will continue in case it is appointed by the adjudicating authority.
Sipraji is asking, can the AR vote can AR vote on behalf of the class of creditors before he is officially appointed by NCLT?
No, he cannot do that because otherwise also the AR doesn't have any power to vote. He now, after this proposed amendment, he will be considered as interim AR, and he will be doing all the functions of AR. This is after the amendment. Now this amendment is proposed that he would be functioning before the order of the adjudicating authority, and he will be functioning fully without any restriction. However, the application will also contain a kind of clause informing the adjudicating authority that the AR is also functioning from the date of submission of application to NCLT.
Then another question is that if creditors have accepted extinguishment of debt in resolution plan, then personal guarantor is still responsible for guarantee.
Personal guarantors are responsible for guarantee. There is no
even if they have extinguished the debt is extinguished in the resolution plan. That is the clarification also that has come in now.
Yeah.
I think that's about it. Yep.
So I think thank you very much. Again, a pleasure to be connected with you. And as we always say, that this is our way of learning. Thank you.
Thank you. Thank you, everyone.